Good afternoon. Thank you for joining us for today's Lunch and Law. How the SEC and FTC unconstitutionally stack the deck in their favor with ALJs. We'll be covering yesterday's Supreme Court arguments in the Axon and Cochran cases. But before we begin, a question for the audience. Before a federal trial judge, how often do you think that agencies like the FTC and SEC win their cases? I see some laughs. Clegg wants to jump in. What do you think, Clegg?
I don't know. The government probably wins 60% of the time, maybe 65%.
That's about right. It's about 60-40 before federal judges. The data is not great. It's sort of hard to capture. But the one thing that we do know is that that number jumps to nearly 100% before their own in-house adjudicators. And that's sort of one of the key issues that's underlying these cases. Who gets to decide constitutional questions, certainly structural constitutional questions, before agency adjudications? We have an excellent panel today. We'll be talking with both Peggy Little, who is the Senior Litigation Counsel here at NCLA. She's on my far left. She's represented Michelle Cochran since 2018. Last December, Peggy secured a ruling in favor of Ms. Cochran by the en banc Fifth Circuit Court of Appeals, which launched both the Axon and Cochran cases to the Supreme Court. Seated directly next to me is Michelle Cochran, NCLA's client. Michelle is a native Texan, certified public accountant, and single mom of two girls who've essentially grown up with this case. They're now in high school, and her oldest is headed off to college next year. And finally, we have Pam Peterson. Pam Peterson has represented Axon, formerly Taser International, since 2005. She's been in-house since 2012. She's a former Ninth Circuit clerk, partner at a major Phoenix firm, and chief assistant U.S. attorney for Arizona. So thank you and welcome to this excellent panel. We will be taking questions at the end of the presentation, but I think to kick it off, I think, Peggy, can you give a rundown of how the Cochran case got where it did?
We represented Michelle since 2018. She was sent to us by her friend Ray Lucia, who we also represented at the time. And Mr. Lucia's name will probably come up again today. She was in a situation where she had been through one complete administrative trial that had harsh penalties, and a judge who has since left the SEC. And he's an interesting character to know about. His name's Cameron Elliott, and he has the dubious distinction of having been called out by Justice Kagan at the Supreme Court, who said that when Mr. Lucia's case went back on remand, it would not go before ALJ Cameron Elliott. And that's important to know because Mr. Elliott was out there bragging to the Wall Street Journal and the New York Times that he had always ruled in favor of the agency. And he would say to people before him that were in settlement discussions that if they contested the charges, he would hit them with the maximum penalties. That's exactly what happened to Michelle. She had a very draconian penalty of a high fine for an accountant. Her crime was paperwork violations, uncompleted accounting work, and she also was threatened with suspension, or she was held to have her license suspended for 5 years. Then, after Mr. Lucia wins his case and learns that, and we all learn that the ALJs have not been constitutionally appointed, the SEC did appoint their judges. Everybody had to go through a new trial. So having gone through an extensive process of adjudication already, that was vacated because the judge was not constitutional, and Michelle faced a second proceeding and came to NCLA.
Peggy, I want to ask just a quick question about post-Lucia. I mean, how did the SEC do this, I guess, reassignment of their ALJs?
Well, interestingly, they got rid of Mr. Elliott, and then they assigned, I don't know that for a fact, but he did disappear rather shortly after the Lucia decision. And then they reassigned about 100 cases to a new judge so that people would have to go through the administrative process all over again. And you're talking about a years-long process. the need to pay an attorney if you can afford one to defend you. This was a very disturbing situation that Michelle faced.
I don't want to jump too far into the discussion about the arguments yesterday, but I don't remember this coming up. How many ALJs does the SEC have, or did it have at that time that it did the post-Lucia reshuffle?
It had 5 ALJs. And one of the first things I did when I came to NCLA was work on an amicus brief. And one of the things Philip Hamburger asked me to look at is, are these qualified judges? Not a single one of them had a background in securities law. They were mostly Social Security judges, and then I believe one came from the FTC, and she was a sort of a radio and television specialist. So in that brief, we had a lot of fun making the argument that the expertise emperor has no clothes, because one of the things that is always argued in favor of these adjudications is, well, these judges are experts. The FTC, Pam can confirm, has 1 ALJ. So one of the things we hope to dispel in this session today is that if administrative adjudication is taken away from agencies and put back in the courts, it's a very small number of judges' work that is involved.
And Michelle, so my understanding is that up until you came to NCLA, you actually were pro se. So
I was.
Can you sort of, well, let's even backtrack this. Do you even know what an ALJ was when the SEC came to you?
If I had read that Wall Street Journal article that talked about Cameron Elliott never ruling for the people, I would not be in this situation right now, because I would have run and settled like everybody else. I was subpoenaed on the same day with the SEC and the PCAOB Wells orders that came to my house 3 years after I had left working for the firm in question. And that was crazy. So I immediately researched up all the great securities attorneys in the Dallas area, actually went down to Austin, found some people. But found one that would help me just kind of get through the initial process. The single mom, put my $50,000 deposit on all my credit cards, maxed them out. It was rough. It was really, really rough. But I needed representation. Went to several meetings, a lot of discussions with them. And then when the ALJ was appointed, my attorney was like, you know what? I think you really understand this case a lot more than I do. I don't think there's anything else I can do to help you. You need to take this on pro se. Little naive me, I'm like, I'm not guilty. I'm sure I'll handle it myself. So I think I probably should get an honorary law degree based on everything that I've read and researched over the years. But I felt I had the best case. I knew the laws. I knew exactly where their arguments were, where mine were, and I was going to go in there and win this. I had no clue that Cameron Elliott had ruled against me or against my former people 100% of the time. It was tough. It was really, really tough. The 2 days that we were in the hearing. I will remember though that the prosecuting attorney gave me a big hug afterwards.
Mm-hmm. That's unusual.
It was really weird. And he was like, you actually did so much better than a lot of securities attorneys, because I knew my stuff and I was not guilty. But he probably also knew he was going to win. But one thing really,
I was just saying, it's a little baked in the cake already.
Probably so. But one of the things that was really interesting very early on, when we were having a call with Cameron Elliott, I was in my kids' carpool line. I think they were in elementary school, and it was Cameron Elliott, the enforcement attorney, and myself. And I think Susan Cisneros was on the call. And so anyway, we...
and Susan was another CPA at the firm.
Yes, she was also pulled into this at the time. We were the ones that were not going to settle because, we were naive and we weren't guilty and we were going to prove our case. And I remember them talking and I was like, excuse me, don't you have home court advantage? I don't really understand. Like, you work for the SEC and you're the SEC? I remember being super confused. And then I
No, you weren't.
And then I got some paperwork and I'm like, but wait, you have the same address. How are you independent? And of course they talked all about, oh, we're on different floors, we're in, all these different things, we're so independent. And I thought, wow, okay, that's kind of doesn't seem fair, but this is the process, and let's go with it. So,
and I think what's interesting though is I will say survived the process with Cameron Elliott. You got a liability determination against you, and then the Lucia case comes out. So you get thrown into this wheel of ALJs, and you go through it again. And that's about the time you came to NCLA.
Yes. It was in 2018. I was here with my daughters. We were visiting the White House for Christmas, and I called up. I think Ray had called you up and said, "Talk to Michelle." And so I came in here. I've met in this very room. We had a great meeting, and then I was with my daughters at the Washington Monument and got the call that you guys wanted to take my case, and it has changed my life. Seriously, I just want to hug you guys because I thought I understood the process, but it's not a fair world out there. And unfortunately, not knowing this whole system was something that I was just not privy to. So you guys have let me sleep at night. I don't have to write legal briefs
That's the wish of most people, right? Well, except for some of these, except for us, this is what we live for.
Right, I'm a CPA, not like an attorney, but I guess I get to spend my nights not writing legal briefs, so that was huge. But just knowing that I was in such good hands was just a turn in my life. This is where my story gets good, when I handed everything over to them. So thankful, so thankful.
Thank you, and I'll speak for Peg in this, and I think the rest is thank you for trusting us with that.
Absolutely, thank you for trusting me.
And I do want to talk, Pam, with Axon. I think what's interesting, as we just heard from Michelle's sort of the small fish that these agencies go after, but occasionally go after bigger fish, corporations like Axon. Can you give a little bit of background? Because obviously the Axon case comes up in an antitrust framework, and so if you don't mind just giving a background to the Axon case.
Sure. Well, I think it's been really great, to get the FTC involved in the same discussion, because so much of the court cases have all been in the SEC context. And of course, this is a broader issue than just the SEC. So my company, Axon Enterprise, we used to be Taser International. We are a leading technology provider for public safety really around the globe. And in 2018, we acquired a small, failing competitor called VView. And VView was in the same body-worn camera, digital evidence management platform space that we were, but was buried in debt, had 3 days worth of operating cash at the time that the deal closed. And I think one thing that's important to note here is that we did not seek out to purchase VView. They came to us. And they came to us after their parent company, Safariland, had really shopped them around the industry, and several other major players who had considered this acquisition said no. This was a relatively small transaction. Total value was about $13 million, so way, way below any kind of HSR reporting requirements. Something that we really didn't, perhaps being naive as a company, we'd never been involved in this kind of a situation before, but didn't really think was going to be on anybody's radar screen. And very quickly, we got an investigation letter from the FTC and got thrown into what became the next 18 months of just very difficult situation for the company, very expensive. We spent $1.6 million just in defending the CIDs before any enforcement action or anything was even brought. And so we were quite surprised by the whole thing. Became marred in the process very, very quickly. And we're just shocked that this type of a system could actually exist in the United States of America. And so we went through the investigation process. It became clear that they were going to file an enforcement action against us. We volunteered to divest the company and all the assets that we acquired, and to infuse a divestiture buyer with $10 million in operating cash. And the FTC said no. So you have to wonder, if you really are about putting competition, back in the marketplace, like, why not? And so we met with them to try to figure out whether there was a way we could come to resolution. We met with all the front office people and the commissioners and whatnot, and and we were basically told, no, you need to basically give us a blank check, was their term, a blank check, and you have to basically put your own independently developed intellectual property on the line. It has to be part of any deal, so that we can basically create an Axon spinoff that's a clone of the company that could use our own intellectual property in competing with us.
Pam, I just want to. That's intellectual property that Axon had and developed prior to the acquisition.
Exactly, had nothing to do with this acquisition, and clearly something that, from a legal perspective, the FTC could never, as a remedy or any type of a legal basis for doing that. And the only way you get to do that, right, is you have to have a government agency who is so convinced that it is always going to win, and you are going to give up in the settlement process, so that they can force you basically into these types of agreements, when they really don't have any authority to be imposing that to begin with. But what we've seen happen, and happens over and over again with the FTC, is that companies do settle. They abandon their mergers. Now, this was a consummated merger. I mean, it had already happened, right? And so, as actually Judge Chappell, who was our ALJ, is the only ALJ at the FTC, when we had an initial settlement conference with him, he said, look, this is a consummated deal. Can't you guys settle this? It's hard to put Humpty Dumpty, sort of back together again, which is what then got us engaged with these conversations with the FTC. And so we decided we were going to draw the line at our, we'd spent over $200 million in over a couple of decades in developing our own cloud-based platform for digital evidence management that won all kinds of awards, and whatnot. And we were just not going to go there. And I feel really blessed, really, to be working for a company that will stand up for principle. Most of the folks who find themselves in the FTC's clutches, do not do that. It is very difficult, right? Because you have reputational harm. We're a publicly traded company, so your shareholders are wanting to, what's going on with this and what's the risk. And when these things go on for years, and that's, you're always answering those questions. You're having to do disclosures in your SEC, filings. And for us, we have, our customers are law enforcement agencies. They are branches of the federal government, right? And so every time we have to respond to an RFP, and they have disclosures that you have to make around, government investigations and those types of things, and we have to repeatedly, do that. And so it is a very difficult thing and very costly. I mentioned the $1.6 million that we spent during the course of the just the investigation process. But once the enforcement action was filed against us, in the year 2020 alone, we spent $20 million more defending this action. It's very expensive, which is why you don't see companies, like ours, really taking this on, because it's a real investment, and you have to really be, I think, as we are, really focused on principle. And we're just not going to be, railroaded in this, kind of a situation. So we filed in federal court in the District of Arizona. We brought several important constitutional challenges, not just the dual layer protection ALJ issue that has been, the story of Michelle's case, but additional issues really going to the structure of the entire FTC, whether the combining of these investigatory, prosecutorial, adjudicatory, and the first line appeal. Right, you have a situation in the FTC where even if you win with Judge Chappell, the first line appeal goes to the commission. These are the same people that voted to sue you in the first place. There's obviously very much confirmation bias, going on. And what we see happen is that even when the ALJ and the FTC setting rules against the FTC, the commission 100% of the time reverses that. They change the findings before you go up on appeal. And then if you can even make it through that process, which most people don't, there literally have been in the last quarter of a century 2 cases that have actually gotten to the appellate level, you now have a very deferential standard of review against you, and it's a very difficult situation to overcome.
Well, and that's a good segue into the discussion of yesterday's arguments, because I do think that deferential review aspect was brought up in some ways, right? And it gets brought up in this idea of, well, these cases look very different if they go through a district court versus an appellate court. And I think, could you, Peggy or Pam, dive into how that operates?
Sure. In Michelle's case, she challenged some due process aspects of her second adjudication, but principally concentrated on the judge's protection from removal, because the problem with these administrative adjudications is that the judges are insulated from any kind of accountability or control, and that violates the Constitution. One of the most interesting things that happened yesterday is what was not said. Not a single justice said that there was a problem with the removal claim. The underlying assumption of the entire argument was, of course, there is a problem with these removal protections. So one of the things that I took away from that is that there may not be, on the merits, much of a dispute on the court about that. It certainly did not come up at argument. Now, the argument addressed the statutes under which both the FTC operates and the SEC operates, and Justice Gorsuch landed some pretty powerful points on that. He said the case for federal jurisdiction seemed clear and indisputable. At one point he says, "What am I missing here?" And he said not to be simplistic, and there was some jocularity around that. Paul Clement actually said, "I think straightforward is a better word than simplistic." And then they agreed to agree on textual, and that takes us right back to the statute, because one of the things that we have argued in Michelle's case is that the case law can get very atextual, and so we rested our strongest claims on the fact that the SEC Act did not strip jurisdiction, and that is something that goes back to 2010 in a very important case called Free Enterprise Fund. And in Free Enterprise Fund, the court decided 2 things. First of all, unanimously, it held that bringing a challenge on removal protections belongs in federal court. And that was the issue that was argued yesterday. So we had a precedent that had unanimous support on the jurisdictional question, but also Free Enterprise Fund said that only one layer of removal protection is permissible at law, and these judges have 3 in the SEC statute. Gorsuch was really powerful in terms of reading the statute, and he kept asking the Solicitor General office, well, the FTC requires there to be a rule, an order, a license, a sanction, relief under the statute. None of those things are here. People are challenging the qualifications of the judge to rule in their case. He also, in the Cochran part of the argument, made the same argument under the SEC statute, but that requires a final order. Also, the justices correctly discussed what the standard is. There is a presumption in favor of district court jurisdiction. 1331 jurisdiction to take constitutional claims to federal courts has existed for hundreds of years. It goes back to Marbury versus Madison, and furthermore, any statute that purports to strip that jurisdiction has to be clearly stated.
Well, and to that point, and I think Paul did an incredible job. I went back to the transcript and pulled this because I thought the way he put this, favor of jurisdiction, it was so eloquent. And he said, we're going to have a rule for edge cases, which I think, sort of to the extent that Cochran and Axon are a little bit on the outer ends of what agencies may be doing in their enforcement. I'd rather live in a republic where the rule for the edge cases was to err on the side of giving the citizen early access to the courts as opposed to erring on the side deferring judicial review. I just thought that was such an eloquent way to sum up the core of what is going on here.
And Justice Gorsuch said it in a different way. He said to the government attorney, I just want to make sure I understand. 1331 grants jurisdiction to district courts. The FTC Act grants jurisdiction to courts of appeals for cease and desist orders. There's no withdrawing of jurisdiction anywhere in these statutes. And then you turn to the APA to make your case? Not a good moment.
Well, and I think, I want to turn, Pam, I don't know if you have a follow-up on that, but I do want to ask some questions about the APA claim, because Justice certainly spent a little bit of time on that, but if you want, to chime in on anything Peggy just said.
Yeah, well, yeah, I think it's very interesting that the government, they kind of realigned the parties after, of course, the Cochran case was successful in the Fifth Circuit, en banc, and then did a combined answering brief, to both. They, I think, tried very hard to make the cases the same. I think one of the things that's really interesting and important to us, quite frankly, is that our claims go beyond just the separation of powers Article 2 issue. And what you heard, I think, yesterday was, some concern, certainly, from certain members of the bench relating to where do you draw the line when you're talking about due process issues? But I think, as Paul also put very succinctly, we're looking at when you talk about edge cases, but in our case, there is no cease and desist order, right? The Ninth Circuit did stay the administrative proceedings, and so a week before we were set for trial. So that hasn't happened yet, despite the cost already, and so we were in a situation where the Ninth Circuit really stopped that process. But we made clear that our due process claims don't have anything to do with the merits of the antitrust action. We are not challenging any agency action. There's not been a cease and desist order. The structural and procedures type questions, and we call them cross-cutting procedures, so things that affect any party that's going to be before this agency, not just us. There's really no entanglement with the merits. And so those are the kinds of due process claims that are important. And for us, I don't want to talk a little bit more, but perhaps later about our clearance process claim, because we think it's so critical.
I wanted to jump to that. That's the black box claim.
Yeah.
As it was referred to for those listening, I think it tended to be called by the government the black box claim, but that did come up for a substantial part of the argument.
Right. Because I do think for us the separation of powers issue is important. It needs to be decided. It's way past due to be decided, right? But that's going to be more, in my view, a win for the lawyers, than it is necessarily for a company in my, situation, because that's still going to put us back at some point once they fix the constitutional issues, they amend the statutes or whatever. We're still going to be back into the administrative proceedings, into this very unfair home court advantage that the FTC has. And so we need a broader rule than that. And so one of the things that we challenged was this clearance process between the DOJ and the FTC, which share antitrust jurisdiction. And it really is an uncodified, just sort of made up situation between these two agencies as to who's going to take what cases. And so in our belief, you put very similarly situated companies in merger situations, and you have very different rights and obligations depending on which bucket you end up finding yourself in. And it really can be an outcome determinative situation, like Kara started with. The DOJ in federal court maybe win 60% of the time. You get in the FTC's administrative position, you're going to lose. I mean, you're just going to lose. And so when you look at the differences, I think it's you go to federal court, you get a Article 3 judge. Right, you go to the FTC's process. You have an FTC appointed ALJ who's on their payroll. Right, in federal court, the rules of federal civil procedure and the rules of evidence apply. They don't apply. The FTC has their own rules. They do their own. They do their own thing.
And then what we talked about too is that when it goes up on appeal, they're given deference to that. There's sort of like when you go up through the appeal after the commission, and this is true going through the SEC too. There's almost like a double-baked due process problem as a result of possible failures in evidentiary or civil procedure type rules.
Right. You have a situation where the standards are different too. In federal court, it's a substantially lessened competition standard, and in the FTC, it's just a much more opaque unfair competition rule, which has really never been well defined, and it just leaves them open to sort of taking whatever position that they want. You get a direct appeal, obviously, from federal court. In the FTC, you go to the commission first. They can de novo change the ALJ's rulings to whatever they want, and then it goes up, to the finally to an Article 3 court at the end. And then you have the clear error type of standard of review for factual findings in federal court, and in the FTC proceeding, the statute says the factual findings are conclusive if supported by any evidence, right? So you are, even if you can get to an Article 3 court at the end of the day, that too then is so stacked against you. So the clearance process situation, really where we believe is that there's constitutional issues there. We tried very hard in the FTC proceedings to get discovery relating to that issue to support that claim. We were shut down at every single turn. So here we have this preserved claim, but if we ever get to the Article 3 court at the end of the day, there's no evidentiary basis to support it because they denied us on answers to written discovery, to taking depositions. We did FOIA requests to the DOJ. We were shut down there and multiple appeals there. So we have not been able to get anything, from either agency relating to support this, and it's not public. None of it's public. None of it's statutory, and so it's a real challenge.
And obviously challenges for the companies, but too as sort of consumers, right? If the idea that protecting against anti-competitive acts is beneficial to the consumers and the citizenry as a whole, then what does FTC and DOJ have to hide in this, right? I mean, that's something that's always confused me from reading your briefs very early on about the clearance process, is what's going on here?
Yeah, and I think too, because one of the things was talked about yesterday was sort of like that agencies don't have expertise, right, when it comes to constitutional claims, and in Free Enterprise Fund, the court even said they don't have expertise or competence, right, in this, in this area, and so the question usually between how you're going to divide cases is like, do the different agencies have different expertise in these industries based on who it is that they're taking on their cases or not? And we just really don't know what are the benchmarks in terms of who
we
takes
do know.
anything.
We do know because Free Enterprise said that agencies lack competence to decide those questions. So Justice Gorsuch pointed out that Free Enterprise Fund was a rule of decision here, and he was joined by Justices Roberts and Kagan. Even Justice Kagan said, doesn't it stand as a pretty clear barrier to your argument? And Justice Kagan also went on. There's there's two cases. One's called Thunder Basin and the other one is Elgin. And I don't want to get too much into the details other than to say both of those cases really did not apply to this situation because in neither of those cases was somebody making the kind of constitutional challenge to the administrative adjudication that both Axon and Cochran were doing here. And but one of the points that Justice Kagan made was that the government had pretty much dropped its Thunder Basin argument, and she confronted them saying, I'm surprised you don't even get to the argument until page 51. Are you afraid of losing under Thunder Basin? And that was a pretty revealing comment from a justice that knows what she's talking about in terms of administrative law.
Well, I will say, I thought there's a handful of zingers yesterday, but Justice Kagan had some harsh words here and there, and I was even taken aback in terms of, I think that, the one thing that happens during these arguments is that the justices don't talk to each other beforehand. So they're signaling to each other from the bench while they're also having a colloquy with the parties in front of them. So I think that you see a lot of tea leaf reading after these for this exact reason of, what was Justice Kagan really sort of signaling? I will say, I want to turn to Thunder Basin for a bit because I thought, Justice Kavanaugh raised some concerns about sort of the way that maybe Thunder Basin is the problem. I think that, there was a funny moment where I think Paul had called him, beautiful thing about Thunder Basin, and Justice Kavanaugh jokingly said, well, I wouldn't call it beautiful, right? Because there is an unworkability. I mean, both of you litigated this at the district court level and before the courts of appeals. What is the thing that lower courts are really struggling with Thunder Basin about?
Well, we made the argument that Thunder Basin is atextual. It's a sort of a made-up case where you have three factors. And the whole purpose is to try to discern where Congress might have divested jurisdiction in setting up an administrative rule process. But as Justice Kavanaugh said, Thunder Basin has not been helpful. We argued that it was irrelevant. But we also agree with Paul Clement and Axon that even if you apply Thunder Basin, the agency lacks competence or expertise. The issue is wholly collateral, to the way that Pam put it it cuts across all claims. And it's not something that the ALJ even has the power to decide. And so we've talked about Free Enterprise Fund, which really provides the rule of decision in this case, in Thunder Basin and Elgin. But there's a third aspect that came out of the argument that I think was very powerfully in our favor. So if you recall, I went through the statutory analysis as Justice Gorsuch did. We've talked about the case law analysis, and several of the justices admitted that Free Enterprise Fund decided the issue. But then we get down to the guts of the case, and that's logic. How could it possibly make sense to go through an entire years-long process to reach the constitutional issue, which, if you are correct, and Mr. Lucia proved that these claims are good, you have to go back and do it all over again. And here's some of the quotes from the argument. Justice Alito says, what sense does it make for a claim that goes to the very structure of the agency having to go through the administrative process? He added, isn't it in your interest to get this decided soon? It hangs over all of your proceedings. Justice Roberts talked about a constellation of cases around some fairly basic propositions. And to have it go over and over again, it does make a good case for direct resolution of these claims to be very strong. Justice Thomas took a little bit different approach. He said, what would it look like to have an ALJ decide these things? That's a great question, because the ALJ would have to say, by gum, I'm unconstitutional.
And that happened in our case.
Yeah.
So we did challenge the ALJ in the administrative proceedings. He recused himself because he's like, I can't decide my own constitutionality. Kicked it up to the commission, and you can guess what the commission.
Good on him.
Yeah, you can guess what the commission did with it. Right? Is these, So that's a problem. I think on the Thunder Basin factors, in my perspective, what a lot of the circuits have done is sort of just focused on the meaningful review piece and kind of threw out the wholly collateral and the expertise, issues. I don't think that was ever the intent of the test or of the factors, if you want to call it that. But I think we would all agree that it's not. The courts have looked at meaningful judicial review to be if you have the potential someday of eventually getting to an Article III court, that's enough, and you know, it's not, that takes meaningful right out of the test, right?
And that was like Justice Alito's point. It's because, well, it says meaningful, and meaningful means something.
Right. And I think if you look at the Ninth Circuit decision in our case, and some of the, I was hearing a little bit of mirroring some of the language from the majority decision there, where if you read that case, there was a very strong dissent by Judge Bumate, who went with us, and then the two judges in the majority. It was the most sympathetic opinion I think that I've ever lost with, you know, right? So they did say it makes little sense.
It's a balm,
right? It makes little sense to make a company go through all of this for all of these years, and if we were writing on a clean slate, we'd agree with the dissent. But they felt, I think, based on a misreading, in my view, of Free Enterprise Fund, that they were sort of stuck with that. They agreed there was no agency expertise. I think the issue for the wholly collateral piece, though, for me, there's been this, some of the dissents in the circuit level courts have done the same thing, where they've said, you really need to be looking at, are the merits of the agency action intertwined with the constitutional issues, so that if that situation is the case, then it's not wholly collateral. And then in our case, and in some of the other ones, the judges, though, have really glommed onto some language from Elgin about, you know, if it's the procedural vehicle that gets you there. And so what the majority in our case did in the Ninth Circuit was say, because even though it doesn't have anything to do with the antitrust merits, which they agreed, but because you went to federal court and asked for an injunction to stop the administrative proceedings, it's the vehicle you're using to stop this, and so it's not wholly collateral, which would of course be the case in every situation. You could never meet that requirement if that's what the test is.
And I'm going to ask the hard question now, because I think, at least listening to the justices yesterday, I mean, there seems to be what is Thunder Basin? Is it factors? Is it tests? Is it weighing? I mean, it got called 3 or 4 things in the course of 2 or 3 minutes.
Including unhelpful by
Including
Justice
so the
Kavanaugh.
big question I have is, you know, sitting here today, can Thunder Basin be saved? Can it be made workable?
One of our amicus supporters actually made the case and said Thunder Basin just needs to go away. And I think that's Justice Kavanaugh's opinion as well, because it creates this multi-part test. It's very malleable. Nobody knows. One of the things that came out at argument yesterday, nobody knows whether you have to win on all 3 to win, or is 2 good enough, and which one's most important. And this is all made up to begin with. There's nothing statutory about it, which is why, in our view, the statutory claims were the strongest, but the logic claim is also very, very powerful. When Malcolm Stewart, who is the person arguing for the government, the chief asked him, would it not be a waste to send even these structural claims to an agency? And Stewart responded, well, the agency could explain, for instance, from its perspective, why it was either a good or bad thing to have ALJs with for-cause removal. And what Justice Roberts responded to, he said, it sounds to me that you're just saying the agency might write a brief, presumably defending the structure of the agency, which it can do when the case goes before the district court, the underlying assumption being, and that would be the court that had the authority and the constitutional competence to decide the question. And here's a fun fact. We started talking about Mr. Lucia early on, and he really broke a lot of ground for what came afterwards. But in his case, when the commission reviewed this removal argument and also the appointments argument, 2 out of the 5 commissioners filed a dissent. The majority, the 3 majority commissioners said, ALJs are constitutional and everything the agency does is constitutional, and the removal thing is not an issue, and the appointments claim is not an issue. And 2 of the SEC's own commissioners said to the majority, thank you very much for sharing your opinions on this, but that has to be decided by an Article III court. And that's what's so interesting here. Pretty much everybody knows that the removal issue is a constitutional issue that the agencies do not have competence to decide, and yet they've been getting away with that for a long time.
Yeah, it sounds as though everybody is in agreement of who gets to decide. It's just a matter of how
and when.
How and when, right? How do you get there? When do you get to ask the question?
And the when is really important. I mean, although the cases yesterday were argued right on straight jurisdictional grounds, we actually had presented a second question, which was to get to the merits of this issue that not surprisingly, the court didn't take because it hadn't been briefed, all the way up, although pure issue of law, they clearly could do it, so we thought we'd take a shot at it. But we really need to get to the heart of the actual merits briefing on these claims and get them back up there to the court. And we actually, have also preserved the issue of, is Humphrey's executor due to be overturned? Is the whole structure of the agency something that needs to be reformulated, and we want to get back up there on that issue.
Well, and to your point about wanting to get there on the merits, I think as Chief Justice Roberts had said and Peggy quoted, there is an acknowledgement that there's a constellation of cases, and I want to make it clear that they're not all arising in the SEC and FTC context. NCLA has another case that's under DOT. I believe somewhere under HHS. I mean, where are these cases arising? Are they systematic across the government, or are they only happening in agencies that have enforcement power?
Well, they're certainly arising in agencies with enforcement power that have these schemes. And at least the agents, with one exception, the agencies I'm familiar with, none of the statutes under which the agencies conduct adjudications strips jurisdiction from the federal courts, except, I said one exception, the FTC statute does have that in there. One of the arguments we made is when Congress wants to strip jurisdiction from the courts, it knows how to do that. It was very clear in the FDIC statute that it had, and it's very, very, very clear under the 34 Act that Congress did not strip jurisdiction for constitutional claims.
Well, and that was something Greg Garr, who argued on behalf of Michelle, I believe it was in his closing, he said that exact thing is, we know Congress can strip jurisdiction, right? They know how to do it, they can craft that language. And so to me, one of the issues with the statutory construction argument is it's almost too simplistic, it's too straightforward. It feels like there's a trap door underneath it because it's too obvious. And I think that might have been something that justices were certainly struggling with. I think I saw that in some of the questioning yesterday.
Well, but that's silly, because in fact, if it's that straightforward and that simplistic, and there was some joking about that, how did we get into this mess where, we had, at the time of this argument, there are 7 circuit courts of appeal that have held that you cannot take this removal question to district court in the first instance. The only court of appeal that ruled otherwise is in Michelle's case, and even there she lost 2-1 the first time we had it heard by a panel, and then we won 9 judges to 7 when we argued it before the full circuit court of appeal. I recommend that decision for reading, not only because of the majority opinion, which sets forth many of these arguments in a very clear way, but there's a concurrence that talks about concerns that were expressed at the time that these various adjudication schemes were set up, and that the courts at the time, this would be in the 1930s, shortly after the 34 Act was enacted, were very, very concerned that these bureaucrats would start stripping away people's individual liberties. And one of the cases that gets a lot of discussion in that concurrence is called Jones versus SEC. And the ringing language that the Supreme Court talked about depriving people of their individual liberties and the power of agencies to do that, it reminds you of why we founded this country on the idea of having adjudicative power in a separate branch of government. Right now, as Pam said, the agency that charged you is also your first court of appeal. And as Michelle learned to her dismay, they all are at the same address, and perhaps the fact that they are on different floors isn't enough of a separation.
I think the FTC is spread against 2 addresses, but that's still a little too close for comfort.
They're on the same server as well.
That's right.
Peggy, you mentioned earlier one of the amicus briefs that you thought was particularly powerful. I believe altogether at the merit stage, there's something like 18 briefs in favor of Axon and Cochran. Did you see any themes from any of those briefs start showing up yesterday during the arguments? Was there anything that stood out to you that you maybe sort of cut through amongst, this like incredible chorus of support that we were able to develop?
I'd like to cue up a song right now. It's called "How Long Has This Been Going On?"
That was Justice Thomas.
Justice Thomas asked exactly that question. And one of the more powerful of the amicus briefs in Michelle's case was written on behalf of Ray Lucia, George Jarkissi, and others who had gone through these extended, Christopher Gibson, also an NCLA client. And these, Mr. Jarkissi, Mr. Lucia, and Mr. Gibson have been in years-long administrative proceedings. For Ray, it was 8 years. For Mr. Jarkissi, 7 years. For Mr. Gibson, it was, I think, 5.5 years. And there's a gentleman named David Bandamere in the 10th Circuit who's had been 10 years under this agency power. I think Justice Thomas was very concerned about that. I also sensed that other justices joined in that concern. And that's one of the great things that the amicus were able to set forth before the court. Because normally in a court, district court, the time from charging to resolution is about 2.5 years. And I recognize that a lot of cases settle, so you have to adjust for that. But there's no question in my mind that the administrative process which is totally under the control of the agency, can drag on for years and years.
And Peggy, to that point, and I'll refer to them as the post-Lucia cases, the cases that were then pending in some way, like Michelle's at the time the Lucia case was decided. There's still, like a universe of 15 or 30 of those in some aspect of commission adjudication right now. They're in the purgatory of administrative law almost.
And we know they're in purgatory because the agency keeps granting itself endless extensions to decide their cases. And I think the agency does feel like it's in a bind. It knows that the constitutionality of those proceedings is under question. I don't know if we want to get into the control deficiency issue here, but let's just say there was a disclosure filed in Michelle's case and also Mr. Jarkissi's case saying that there was a control deficiency and that the enforcement staff had been accessing the adjudicative ALJ files. That's a deeply troubling problem. It's like going into a court and the prosecutor and the judge are swapping briefs.
And yet, though, if you look at, even though the FTC's been under microscope for a while, and not just in our case, but in others, as well. But despite that current spotlight, I think if you look at the Altajul case, where the ALJ did rule against the agency, it was a very lengthy, complex proceeding. The briefing, like 1,200 pages, of findings of facts and conclusions of law and whatnot. And if you listened recently to the appellate argument to the commission, it was fairly clear to me that they likely will still reverse that and come out with a different outcome. At least it felt that way to me during listening to it. Right. So I don't think that that spotlight has really stopped the aggressive conduct, I think, of some of the agencies. I do think the amicus briefs did a really nice job of really laying out, the hardships and the burdens to the parties, which is something that's harder for a party to do. And as you saw perhaps yesterday with Justice Sotomayor, who sort of shut down Paul when he started to go into those effects kinds of issues, and that's the merits, and kind of shut that down. But it's critical to those of us, and I think the U.S. Chamber of Commerce has been a fabulous partner through this and has really emphasized the importance of these cases for all American businesses, basically. I think that's true. And I just want to commend NCLA for being such a fabulous partner of hours through this whole process with amicus briefs from the district court proceedings, sort of, all the way up. And Peggy and I have enjoyed mooting each other for our various circuit arguments and things like that. But it's fabulous to be able to have partners to be able to come together and feel that support. And I really appreciate you all.
Thank you.
Well, thank you.
It was interesting. You said that they wanted to stay away from the merits, and you could tell that was a touchy issue, and yet the merits matter here. And one of the things no justice was willing to say out loud is that there's no basis to this removal protection issue. That did not get discussed, and I think it's because Free Enterprise Fund has decided that question. And again, Justice Sotomayor seemed to want to shy away from talk about any of the black box clearance process or any other aspect of the merits of the case.
So we have about 5 more minutes until we're going to start taking questions both from our online audience and our audience that's joined us here today. I don't know, give each of you, is there any takeaways or some final thoughts you may have had from yesterday? Michelle, maybe start with you.
Wow. I never thought when I was sitting there with Cameron Elliott as my ALJ that I was going to be in front of the Supreme Court with this great support through NCLA and with Greg yesterday. Absolutely surreal. And it made me, I've just felt, maybe there is justice in this world and people are going to hear about the troubles this has wrecked my world for, how many years. I started working at the firm in 2007 when my daughter was 5 months old. And all of y'all saw her yesterday, she's 15. Mm-hmm. That's an entire lifetime that is, hopefully this is going to get wrapped up and other people are not going to have to go through the hell that I have.
And can you maybe mention about what this did to your reputation and employability?
Well, when all this happened, I went to the chief compliance officer at the firm where I was in charge of SEC reporting. I said, hey, I got this letter in the mail and I didn't do anything. I am just kind of collateral damage. I work for this firm and, I'm going to fight it. It's going to go away. I got fired. It was horrible. It was one of my favorite jobs. I did a little bit of consulting work, but it was never the same. I feel like I lost 10 or 15 years of my prime earning power just being afraid to apply for jobs because I'm like, oh, they're going to run a background check and they're going to find out I'm like a troublemaker. Every time where I was working somewhere and I'd get a meeting request from someone new, I thought, oh my gosh, they're going to fire me. Even though, I had top performance, it was just this cloud that was hanging over me. We had the SEC after the ALJ hearing called me into the Fort Worth office one day and they had a really great offer for me. And it was just one other SEC attorney and myself. He got rid of all of these draconian sanctions, essentially, no admit, no deny. But I was going to sign over, I had essentially, agreed with these things. But it was going to go away. I turned around in my seat in this big conference room at the SEC. I remember just crying and praying, and turned around. I just, you just get that light, and I was like, you know what? No, thank you. And I stood up and walked out.
And that's what it takes.
It's what it takes. It was the hardest thing, but I knew I was doing the right thing. I was not going to risk my reputation. My dad had been a civics high school teacher for 30 years, and then my brother took his job when he left. So there's been 50 years of my family teaching civics at my high school. I knew that this wasn't right, and I wasn't going to be another statistic in those people who just gave up and settled.
I think the SEC is regretting the day it charged you.
Yeah, it might be.
I sure hope so. Sorry, guys. You messed with the wrong girl. But no, I absolutely agree. And it's I know we're going to make a difference in this. I really do. So, thank you.
And I think it's probably time for questions. I know I've seen some itching faces in the audience here. I imagine online's busy as well.
I remember Axon way back. I think you guys called me very early on, so I followed it all the way up, followed Michelle's case. What strikes me hearing this today is that it appears not to matter who the ALJ is, because you got a hanging judge in the SEC. You got Chappelle, who tries to do his job. I mean, I remember in LabMD, he ruled against them. They reversed him. He does this, they reverse him. I mean, I don't know how he keeps himself going in the mornings because, I mean, but the point is, the person doesn't matter. The process is such that it doesn't matter who the ALJs are. So what are the ALJs there for if they can only give a positive ruling for the agency and never a negative one? How are they actually judges?
Yeah, and it's an interesting question because and I have oftentimes thought you have to be careful what you wish for, because the other thing the FTC could do is put one of its commissioners in there as the adjudicator, right? And I'm not sure it would certainly, in my view, not be any better than certainly. I think Judge Chappell does try to do the right thing oftentimes, but he can't win either, quite frankly.
Thanks. And I think this really points out the whole issue, going back to James Madison, pointing out that the very definition of tyranny is to combine all functions of government, the legislative, executive, and judicial in a single person or agency. What would you like to see either come out of the litigation or perhaps as a policy change to roll back that from even being able to happen? What litigation outcome might affect that, or what legislation or policy changes might sort of dismantle this administrative tyranny that we have established in our agencies?
Well, certainly we want to see a decision in our favor that the removal protections are unconstitutional, and we have a little help from that in the Jarkissi decision in the Fifth Circuit. That the Fifth Circuit has now held that the removal protections are unconstitutional, and furthermore, you have a right to a jury trial. Once you recognize the right to a jury trial, which is something the founders believed in strongly as a Seventh Amendment right that cannot be taken away with you, once that gets recognized, we're back into the federal courts. There was some legislation proposed, I believe it was a congressman from New Jersey, that had the idea of, well, if the SEC can choose whether to go into federal court to charge you or to its administrative proceeding, the person charged should have the same choice. So if they charge you administratively, you can ask to have that moved back to federal court. So that would be a legislative solution. I like things simple. I'm a bright line person, and I think that these constitutional rights always have to be decided in the federal courts. And there was a good example of that at the argument. One of the things Mr. Clement was asked by the judges that seemed to be more in favor of agency adjudication, I believe it might have been Justice Jackson or perhaps Justice Sotomayor, but they asked him, well, isn't your rule too broad? People can just say, I don't like this adjudication and go into federal court. And he gave a really good answer. He said, well, if the agency were to have a policy or Congress were to pass a statute that said, you may not call witnesses in your own defense, surely that would be unconstitutional, and you would have to take that to federal court. And that holds true, right to confront witnesses, your various Fifth Amendment, Sixth Amendment, Seventh Amendment rights. Those are constitutional things. And the whole meaning of a constitutional right is that no legislature can infringe upon that, because it's just a legislature. And the Constitution gives you pre-existing rights and protections that are essential to individual liberty.
And I think for us too, we want to be in federal court. I mean, that just is sort of we've never been afraid of the antitrust merits in this acquisition, but we want to have a fair shake in front of a neutral, Article III judge in order to win that case. And so there's going to need to be legislative changes for sure. And it'll be a while before I think we get there. But I think, and I'm not necessarily a proponent of you just get rid of the FTC. I mean, but there's an investigative function and maybe a prosecutorial function. But when you come down to the adjudication, you come down to the appeals. Let's get into federal court. At that point. And to what Peggy was just saying, I mean, we experienced this in the administrative case where the agency has been very wishy-washy on what really is the market that's at issue here with how they've defined it and not defined it. I mean, it's really been a moving target the whole time. But they've been focusing on large metropolitan police departments, of which the focus seems to be on the 69 major city chief association entities. And yet then when we said, okay, we want to subpoena those 69 entities, they said no, right? And you can only have 18. Or whatever the number was. I mean, it was so it's like you're defining the market this way, and yet we can't subpoena these agencies. So that's what's happening.
And that goes to when you talk about the combining of functions, they make up these rules, or they think in Pam's case, well, we can tell you to divest yourself of your intellectual property. It has no power to do that. And so when it starts making up the rules, in Ray Lucia's case, Cameron Elliott said, well, under the definition of this term that I have found today, you have violated the securities law. And I hope your ear is sharp enough to pick up that is retroactive lawmaking by a judge who's also your judge, to whom your appeal must go to a commission that charged you in the first place.
And I think one of the flip sides of this is because certainly there's been critiques of these cases, and there is some aspect of a Chicken Little fear that the entire administrative adjudication is going to fall. And my answer sometimes to that is, oh, the horror! The agencies will have to follow the Constitution. and
OMG, as the kids say.
I've actually had some people come to my side on that, and they said, when you think about it, it does make sense that you should get, like you said, a fair shake. And how do we get to a fair shake? Because we all want a government that is operating optimally under the constitutional constraints that are set forth. And I think certainly any policy choices are made should always go back to that sort of consideration. Are there any more questions internally? I think there's some.
Question that's definitely not from a lawyer or anyone who knows a lot about this. How far away are we from a day where someone like this will be able to sue for their legal cost and their loss of income?
There's this concept of sovereign immunity, but there's also an Equal Access to Justice Act that has proven very unsatisfactory in recovering those things. And that's one of the many problems with all of this, is the government has an edge. One of the things that I thought was really interesting at the argument too, the government has said, even if these tenure protections are held unconstitutional under a particular circuit, it's not binding on the SEC outside of that circuit. And this is why it is so very important to have the Supreme Court decide these questions.
I think we have some online questions.
Yes, one of our online attendees, specifically about the removal protections, there's some confusion. The question is, how is it going to change anything? What is really being remedied if you say remove these extra layers? Could you say a little bit more about that? Because the people are saying, is this a ticky-tack situation, or is there a real substance to the problem?
Well, one of the distinctions, Mr. Lucia's constitutional infirmity in his case was the ALJs had not been properly appointed. That was fixable by the agency. The removal protections are not. Those are statutory. Only Congress can change that. And one of the points made at argument yesterday, and the justices seem to understand this very clearly, if you thought, well, maybe a court would take away the Merit Systems Protection Board, which is a tenure protecting statute under Title V, Section 7521. Well, there's several problems with that, including affecting a whole bunch of people outside of the particular dispute that you were doing. But no one would contend that the SEC, under its Title 15, has power to go around severing portions of statutes under Title V of the U.S. Code. That's not yet within anybody's conception of what an agency has power to do. So Congress has to fix this. And if we have enough people talking the way we did today, if Congress does consider legislation, we can have some very interesting hearings about how and why, in the first place, the founders assigned the adjudicative function to a separate branch of government.
And I think too it kind of goes to what I was saying before. It's a very important issue. It needs to be, resolved. It needs to be fixed. It's an accountability issue for the agencies. But it's also why, in our case, right, we are looking for also those cross-cutting procedural type and other type of structural due process kinds of arguments to be able to have a line drawn in terms of the jurisdiction that's broad enough to encompass those, I think is important for individual parties and companies like ours.
One other question that's come in from online, and it's a question about how things really work at these agencies. The questioner asks, are the same people potentially the prosecutor in one case and then the judge in another, or is it a separate pool? How does that work? Do these folks all go to lunch together and then they clock in and like, all right, Sam, I'll see you on the, who are you the judge today? There's a question about how that works at the various agencies, if you can answer that.
Through our work, I can tell you all of the above. I'm serious. And maybe not in a particular agency, but certainly we know about the file sharing that was disclosed publicly in the Jarkissi and the Cochran cases. We've seen some state administrative agencies where the guy at the agency is one day the prosecutor and the other day puts on his judge hat. And the problem is these agencies are, for lack of a better term, free agencies because they make up the rules. And then even when they have rules, very often they don't comply with them.
Mm-hmm. We have a question in the back.
In this effort to get your justice here, it seems like the process is already the punishment, just getting through this. And with what the agencies are doing over and over and you going back and forth, you seem like you're like Sisyphus pushing the rock up the hill. Any comment?
Feels that way.
It does. The SEC and the FTC count on the fact that they can win by attrition. They will bankrupt you. Mm-hmm. They will, tie you up in proceedings that have no end. The word Kafkaesque comes up a lot. Sisyphus is another great image in terms of both Ray and Michelle had to go through an entire proceeding, and even if they win on the constitutional issues, their reward is you get to go through it all over again. Something is dramatically wrong. No rational system of justice would be designed to work in that fashion.
Yeah, the do-over thing just is not a remedy, And I think one of the things that came up yesterday too was about when you go to district court, one of the remedies that you're seeking is an injunction, and the Court of Appeals in these statutes, like the FTC situation, they can only affirm, modify, or set aside a cease and desist order. They can't issue an injunction. So the relief you're actually seeking in district court, you can't get at the end of the day from the Court of Appeals anyway. The most you're going to get is a do-over kind of situation. And somewhere along the way in our case too, they talked about there's a part of the FTC statute where the Court of Appeals can send something back for additional fact-finding. Mm-hmm. And so when we've talked about our clearance process claim and how we can't get discovery, it's been like, well, the Court of Appeals could send it back for that. It's like, well, how do you even make the case that that's a substantial issue when you have not gotten, anything? And then if it does go back for that, it's going back to the same commission. What do you think they're going to find, in terms of the rationality of their own black box, rules? And so it really is just you feel like you're a hamster on a wheel.
On the Sisyphus point, one of the things that I've always felt, and this came up yesterday and we talked about it a little, is Justice Sotomayor brings up sort of the cost burden is something that the courts have just long held. It's what you have to bear. And when you talk about this $20 million, $10 million, $50,000 on credit cards just to survive the first is, and I think Paul might have said this in a slightly different way, is that the cost of citizenship?
Right.
And is that a cost we're willing to say? And Peggy and I have talked about this at length of this idea that the courts just push off the actual cost and pressure of all of this is, because it's harsh. It's why they have settled almost all their cases. So I think that I've always found that argument by the courts to be very disingenuous and sort of untethered to the reality of agency litigation.
Another really dishonest thing that I think came out in court, and this is what they call the mootness argument. They say, well, let's give the administrative proceeding a chance. You might win. Well, we know that in 98% of the cases, they all settle, okay? It takes an extraordinary amount of wealth or a very well-funded insurance policy to defend one of these actions. And Justice Sotomayor said, well, you might win, and so a person doesn't care how they win. And that's really a very dishonest way to look at this. Of course people care how they win. Right now the ALJs have no power to rule for or against you. But it is a very costly thing to go through. And getting a winning decision is virtually impossible.
Well, and is it really a win if at the end of the day you've gone through this entire process? It's not just the money, it's the company resources, internally. It's the distraction from what your mission is, and we're a very mission-focused, company. Wouldn't that money be better spent putting it into new technologies to help communities and law enforcement, out there and our public, those kinds of things.
And reputational damage.
Reputational harm, particularly for a publicly traded company, those kinds of things. And so, it's a lot more than just the money.
And 10 years later, for me, I left the firm almost 10 years ago. And so now they want to send me to a Article 3 court to go hear my case.
Witnesses are probably not available. We don't even know if documents are available.
I heard they were in David Hall's garage. The last thing that was the last thing I heard, and that was 7 or 8 years ago. So who knows?
Likely not still around.
Yeah.
So uphill indeed, but I think that everyone on this stage here is hoping we ultimately beat the odds. I see we're running up on time. I want to thank our esteemed panel on behalf of the New Civil Liberties Alliance. I want to thank our audience for joining us at this Lunch and Law event, and we hope to see you at our next one. Thank you all.